Welcome back to the Page Podcast. In this episode, we have the pleasure of being joined by Professor Emily Jackson for a discussion of various topics within medical law. Professor Jackson is an expert in medical law and currently a professor at the London School of Economics. She has previously served as Deputy Chair of the Human Fertilisation and Embryology Authority and is currently a member of the BMA's Medical Ethics Committee. In this episode, we first touch upon regulations surrounding clinical trials and the pharmaceutical industry, before moving on to discussions relating to clinical negligence and, in particular, assisted reproduction. Throughout, we spend quite a lot of time talking about balancing risks and benefits of regulation, what the purpose of the law should be, and perhaps some areas in which it may currently fall short of society's needs. Just before we get into our discussion, just a quick reminder, please, if you like this podcast, then do subscribe, leave us any feedback, or share it with a friend. It really goes a long way. Professor Jackson, welcome on the podcast, and thank you so much for joining me.
Pleasure.
So just to start off with, I was wondering, what do you deem to be the ideal role of law in the medical sphere?
Wow, that's a huge question to start with. And I think there's probably not one single answer. But in some ways, it depends what sort of law you mean. So one type of law that I think is incredibly useful in the medical sphere is regulation, which is laws which make sure that patients are treated safely, that drugs are safe, for example, that they're properly tested, that healthcare professionals are properly qualified. So that there's that whole area of regulatory law, which is to do with making sure that treatment is safe. There are also issues around things like liability. So if a patient is harmed as a result of their medical treatment, the law can step in to ensure that there's a remedy for them if they want to bring an action in relation to that harm. But then there are other areas of medicine where the law plays a slightly different role, where the law is, in a sense, judging what's acceptable and not acceptable. So a good example of that might be in relation to something like assisted conception and embryo research, where there's a statute which sets limits on what doctors can do and what scientists can do. So in a sense, there's not one single role for law. It serves lots of different sorts of purposes. But I think it's helpful for doctors because it enables them to practice within limits that they know they are, in some sense, protected as long as they don't overstep those limits. So you could say things like the restrictions that the law places on something like embryo research. You might at first sight think to yourself, well, that's actually constraining science. But actually, you could instead say it's facilitating it by letting people just get on with their work because it's regulated and they're doing it within a regulated sphere. So nobody can interfere with their ability to do that.
Another question that I had leading on from this is, how do we weigh up the competing harms and benefits of changing a law or introducing a new law, particularly when those harms and benefits can be really quite different, whether we're in the sphere of regulating the pharmaceutical industry or research involving embryos or assisted reproduction?
It's a really good question, and it's not easy. So in terms of what limit should be set on whatever practice it might be, whether it's assisted conception or assisted dying or something like that's primarily a role for Parliament to decide that, to set that out in statute and to, in a sense, lay down the law to say this is what can be done and this is what can't be done. But obviously there are a whole range of competing interests that are taken into account when trying to weigh up what the law should say. And the example you give of medicines is a really important one because it's really complicated to decide when it's safe enough for a medicine to receive marketing authorization and be provided to treatment to patients, because you can't carry out clinical trials on the sort of scale which would identify every single adverse effect, because that would mean millions of people being involved in clinical trials, and that's not really feasible. So the judgment has to be made about when the evidence suggests that the new medicine is safe enough that it can be used in patients. And that's a really difficult judgment. And there are, as I say, competing considerations, because some patients would want to say, we need medicines more quickly. There's an innovative medicine. We don't want to waste time with these long trials. We want to get it into the clinic fast. But of course, if you speed up approval times for medicines, you may get new medicines into the clinic fast, but they may have really serious adverse effects that weren't picked up in these speedy trials. So you've got to weigh up, on the one hand, the benefit of speedy access to medicines, and on the other hand, the benefit of getting really robust evidence before a medicine is used in the clinic. And again, there's no easy answer to that. It's a difficult judgment about what we think is sufficient evidence of safety.
And I think this brings up the point that full autonomy is not necessarily what is best for the system as a whole. I, as an individual, cannot consent to a number of things in the medical sphere that are known or highly suspected to cause serious harm.
Yes, I mean, there are things that you can't give consent to. So, I mean, one really quite extreme example is female genital mutilation is a criminal offence, and the fact that a woman consents is neither here nor there. It's a crime. So yeah, there are limits on what people can consent to. Interestingly, there are very few limits on what you can refuse. So the way in which patient autonomy is really protected in law is mainly through a very, very robust right of refusal. As long as you have capacity, you can refuse almost everything. The one exception is in relation to mental health law, where if you've been sectioned, even if you have capacity, you can't necessarily always refuse everything. But with that exception, the right to refuse is very, very, very robust and robustly protected. But you don't have a right to demand treatment that you want. Doctors don't have to give treatment that a patient wants just because the patient wants it.
Would infectious disease also come into play here?
Yes, and I think obviously the recent pandemic has been extraordinary in terms of what the law did. That it's never before in my lifetime has there been anything like it. So the law tells you can't leave your house without a reasonable excuse, and extreme. I mean, obviously the extreme pandemic called for really, really extraordinary public health measures, which are really, really unusual, because normally, of course, nobody can stop me leaving my house if I want to. But actually, those public health measures were really, really intrusive. Though, interestingly, I think that there is a difference between quarantining people, where you say you can't leave your house, you've got to, and actually forcing treatment on somebody, because if you force treatment on somebody, you're invading their bodily autonomy rather than just restricting their freedom. And the law does tend to treat that slightly differently. So telling me I can't leave my house is a bit different from pinning me down and injecting me with something I don't want.
Logically, this makes sense to us. What sort of precedent was there for this before the pandemic?
Public Health England has long collected data on infectious diseases. So if you go to your doctor and your doctor diagnoses you with whooping cough, for example, the doctor has to report that to Public Health England. So there's a sort of information flow about certain diseases, but nothing like, and obviously if there'd been an outbreak of something like smallpox, say, which has now been eradicated, but were there to be an outbreak of smallpox, extreme public health measures would have been taken. Public Health Act allows that to happen, but nothing that I have no memory of anything remotely like the stay at home, can't leave your house, can't travel sorts of measures to which the population was subject.
And I'd like to turn our attention just briefly back to the sphere of clinical trials, as it's something that we love talking about on this podcast. And I was wondering, what is an acceptable risk for an individual to sign up to? Obviously, we have this sliding scale between things with no known or predicted or logical harms coming from them on one end, and at the other end we have interventions with very predictable harms that can be quite serious. I was wondering how we draw the line here. So we, on one hand, I guess, protect participants in trials, but also, on the other hand, allow research to go forwards with some unknowns still present.
Yes, I mean, I think it's a difficult judgment call to make. And I think most people would think that individuals generally should be able to judge for themselves what risks they want to incur, but with the proviso that there are some risks that we just don't let people take. So the obvious example of the issue where this arose recently has been in relation to controlled human infection studies for vaccines, sometimes known as human challenge studies, where young people are allowed to volunteer to be given a candidate vaccine and then deliberately infected with coronavirus. And it's thought that would be incredibly useful because you could get evidence very quickly, which would mean that you could discount useless candidate vaccines more quickly and know which ones actually you need to put into proper clinical trials. And I think the decision was taken that that's actually okay, that people can consent to that, obviously with a whole lot of restrictions around who you allow to do this. They have to be young, they mustn't suffer from comorbidities, and there would obviously also have to be restrictions on their freedom of movement. You couldn't have somebody who took part in one of these studies and then went and visited somebody in a care home, for example. That would not be okay. But I think there were people who argued that actually we don't know enough about the virus to say that that's okay, that we too much is still unknown and we shouldn't allow people to take that risk. But that's, in a sense, that's another, I think, quite good example of where there isn't a right or wrong answer there. It's just a judgment, and somebody in the end has to, or a collective of people have to take the judgment about whether or not we would allow that to happen.
Perhaps legally speaking, do we draw a distinction between investigations such as this that have potential to bring enormous benefit and those which perhaps do not have as much potential to bring benefit? Do we view the former more favourably and then say in perhaps a different situation, actually because the benefits to society are not as great, then the risk to volunteers is not warranted, even though the risks to participants may be exactly the same in two scenarios?
I think that's an excellent question, actually, because I think instinctively most of us would say yes, that really is central, that you're not going to inject somebody with some potentially fatal disease in order to find out something very trivial. It has to be you have to be doing this because there's a sort of risk-benefit calculation that this risk is not negligible. It could be serious in some people, but the potential benefit is very great indeed. And I think when the potential benefit is not great, there aren't any justifications for those risks. But that leads to a much wider issue about imposing the regular risks of clinical trials on people for marginal benefits. And what's sometimes described as the growth of Me Too drugs, where a pharmaceutical company investigates a new product, which isn't a new cure for a disease, it's just a slight variation on an existing medicine. And obviously there can be gains to having additional medicines to treat particular conditions. So it's not that it's never okay to do that, but if the gains are very, very marginal and the risks are very high, I think we have to ask whether or not those risks are warranted.
Definitely. And one area that might be a little bit contentious, but could be a defence of this, is that more medications drives down prices. So even if a drug is not necessarily better, having multiple examples could improve access to medicines. Absolutely.
And I think it's also good to have a range of medications, because some patients don't tolerate some medicines. So having other options to give them can be really, really really important. So I'm not by any means suggesting that there's no purpose to this, but I think where you've got a whole wide range of treatments for a particular condition and they're cheap and accessible, doing another trial to produce a medicine where the main purpose of that medicine is to make the pharmaceutical company money rather than to give patients a beneficial new option, that can change our risk-benefit calculations, I think, a little bit.
And I think this conversation links in really nicely with one that I had with Vinay Prasad on the podcast as well. And I'm sure if he were here, he would be screaming that in lots of these cases, drugs are not necessarily equivalent to each other. They are simply, by the analysis that has been done, non-inferior. And actually, the difference between two drugs, one of which is non-inferior to the other, can be very significant depending on the statistical measures that you use to prove non-inferiority.
I think that's very true, and I think one area where the media, I think, has some responsibility here is there's a tendency to give the impression to patients that anything that's new is therefore very, very good and very exciting, and patients should want it. So I think patients often think a new medicine is almost by definition a really, really good thing. Whereas in fact, because there's much less data to go on, and we've got much less evidence of how it works in real patient populations, new medicines are more risky. And obviously sometimes new medicines do tremendous good as well. But I think patients often think that anything new and shiny is necessarily better than something well tried and tested, and that's not necessarily always the case.
Going back to what we were just talking about, there is this assumption that anything new must be better because otherwise it would not have been approved in the first place, although as we've just discussed, that is not necessarily the case.
Yeah, absolutely. So what the drugs regulator is deciding when it grants the marketing authorization is not that a medicine is better than the alternative. It's just that it meets some threshold level of safety and efficacy.
One point that I would add to this is that if we're arguing that the risks incurred in clinical trials can be, permitted in some circumstances and not in others, relating to the societal benefit from incurring those risks, then this puts a real incentive and a real justification to make sure that trials are generating data which are useful and effective, and not even that really, but the most useful and the most effective that they can, not necessarily just something that might eke over the bar that the drug regulators have set.
Yes, absolutely. So clinical trial data which doesn't represent the whole population is inevitably a bit flawed because you can't be certain that the medicine can be taken safely by everyone. So one of the issues that we're, I think, running into at the moment is if pregnant women weren't included in the clinical trials of COVID vaccines, there's then this bit of an issue because pregnant women might think, well, I can't take this vaccine during pregnancy because there isn't trial data to show it's safe. And yet coronavirus is very, very risky for some pregnant women. And so actually vaccination is generally very, very much in pregnant women's best interests. But that lack of trial data has led to a bit of uncertainty around safety. And that is a really bad thing. The better the data from clinical trials, the easier it is then to know that something is safe across the population as a whole.
And we move on to questions of equity as well. Even if an organisation turns around and says, OK, we can afford to be risk averse and cut out a certain group in the population. Classically, pregnant women are often excluded from trials. Children are often excluded from trials as well. There is nevertheless a real moral issue with access to medicines.
Yeah, no, you're absolutely right. I think pregnant women with serious chronic health conditions are in a really invidious position because lots of the medicines that they might need have not been properly tested in pregnancy. And you're absolutely right that the same historically has been true for children, that it's been assumed that you just reduce the dose. But that's not how it works. And some children suffer serious adverse side effects as a result of that failure to carry out clinical trials. Though now, to try to redress that, the European set of regulation has put all sorts of incentives in place to try to persuade people to do paediatric trials, like giving extra 6 months more patent protection and things like that, so that there is actually an incentive to do the trials which help with safe prescription of medicines to children.
And I think this slides nicely into my next question, which is, I know you've written about this before, and the idea of independent organisations running clinical trials for new pharmaceutical agencies or even devices. And I was wondering what your thoughts are on this and potentially some of the barriers that could be faced in instigating a policy like this.
Yes, absolutely. I think that when pharmaceutical companies or the contract research organisations they employ to carry out trials for them are doing an investigation, they obviously have a very clear financial interest in the medicine being found to be safe and effective. They also, of course, have a very strong interest in identifying if it's not, because there's no point in marketing a medicine which is going to have to be removed from the market very quickly. So there is an interest in making sure the trials produce good results. But I think you're right that if the regulator itself were to carry out the trials, that might have some advantages in the sense that it doesn't have that financial interest in marketing the products. It's more interested just in whether or not the medicine is safe and effective. So there could be advantages to that. The difficulty, of course, is resourcing. The public bodies don't necessarily have the funds to carry out these sorts of trials. So, of course, against that, you could say the reality is when you're looking at the development of new medicines, that a lot of the preliminary research, the early stages of basic research does take place in universities. It's not all taking place in the pharmaceutical companies themselves.
Although I guess the solution to this, and I think we've made this argument before in the podcast, is that if these trials are going to be paid for anyway, then they can be paid for by industry, but industry doesn't necessarily have to carry them out.
No, I think you're right. I think the regulator is currently funded by fees from industry. That's what funds the MHRA. It's licensing fees that are paid by the pharmaceutical industry. They could just be bigger to enable the MHRA to do more with those resources.
Can we anticipate what the pushback could be from industry were such a policy to be put forward quite seriously?
I think one answer really is that the pharmaceutical industry is politically quite powerful because it makes a huge amount of money for the economy and it employs a great many people. So there does tend to be a tendency amongst government not to want to introduce regulation, which is going to lead drug companies to move elsewhere. So there have been times in the past where a drug company has said, well, if you do that, we're shifting our R&D to another country. So I think that gives pharmaceutical companies quite a lot of clout in terms of saying this regulatory system is not where we want to locate our research and development facilities. And that's unfortunate, I think, that clout exists, as it were.
Cross-border agreements are certainly a way in which I could see the world getting around this.
Yes, and in a way, pan-European regulation of medicines, in some ways, has done a tremendous amount of good by making sure that there is essentially a level playing field throughout Europe.
And I'd like to move on slightly now, on a similar vein, but away from what the law should be to how it should be enforced. There have been quite a few high-profile examples recently where, despite laws being in place, there wasn't enough surveillance, for example, to find out when a law had been broken, or actually there was knowledge of a law being broken, but actually it wasn't followed through to actually enforce it, and therefore the law can lose some of its sting, as it were, lose some of its deterrent properties. I was wondering what your thoughts are on this.
Yes, I think you raise a very important point, and the way in which, certainly in the US, the FDA takes action against pharmaceutical companies for breaches of regulations is to impose eye-watering fines on them, so that they can't factor in the fine as just the cost of doing business. So an example is off-label marketing, where it's obviously phenomenally lucrative if you can persuade doctors to prescribe a medicine off-label, because you don't have to do the trials to show that this new indication is warranted. So you expand your market without having to do very much work. So there have been instances in the US of pharmaceutical companies trying to, in a sense, encourage off-label prescription, and some of the fines that the FDA have imposed in relation to that sort of behaviour have been extraordinarily high, and that obviously does serve as a deterrent. If you're fined millions and millions of pounds for something, then it does make you think twice. But there are criminal sanctions as well on some behaviour of pharmaceutical companies. And many years ago, in fact now, an Australian study, a socio-legal researcher did a study of the internal workings of pharmaceutical industry, and found a phrase that I remember feeling was incredibly memorable when I read about it, that some companies had a member of the senior team whose responsibility it was to go to prison, that they were paid a lot, but if there was a conviction, they were going to prison. And that just is an extraordinary thing, the idea that somebody that might be not obviously formally in their job description, but being understood that would be what they'd have to do if it came to that.
And perhaps that's actually quite similar in a way to fines being small enough that they can be factored in. And actually the most astonishing example that I saw in this area was relating to Purdue Pharmaceuticals and McKinsey actually factoring in the costs of litigation surrounding the marketing of oxycodone. Another example that I find really interesting, which is a completely different one, which relates to security on, I think, cargo ships travelling around, often around the west coast of Africa, where organisations or the owners of these ships have worked out actually it's cheaper to put some money aside in a pot to pay for ransom demands from pirates than it is to actually put security on these ships to prevent it via that mechanism. This is another contentious point, but in these cases, do more people need to be sent to prison, and do you need to make sure that actually there cannot be just one fall guy in an organisation who can be paid a lot of money to take the blame for something?
I don't in any way want to suggest that I think more people should be going to prison, because I don't think prison is necessarily the answer to anything. But I think you're absolutely right that where companies might make a calculation that actually, on balance, it's fine to pay the odd fine and carry on as they were, the fines need to be so great that interferes with that judgment. But more importantly than that is the chance of being caught. That's what will really affect people. But if you think that the chance of being caught doing something that you shouldn't be doing, like off-label marketing, is very low, then the fact that the fine might be huge, again, you might factor that in and say, we can every few years we can deal with that. But if the chances of being found out are very great indeed, then that's less likely to happen. So I think you do need really well-resourced regulators to be able to find this sort of information and keep track of it, rather than just imposing occasional huge fines.
A non-medical example that I'm sure everyone's come across involves Volkswagen and the scandal around emissions standards. And I I highly doubt that anybody at Volkswagen turned around and thought, actually, we're going to do this knowing that we would get caught for it. I imagine there was a decision that was made that said we're likely to be able to put this under the radar and gain the benefits from it without suffering the consequences.
Yeah, absolutely.
And going back, I didn't mean to be flippant around prison sentences, but I do think that sometimes there is not enough personal liability for individuals making potentially criminal decisions or certainly decisions that rip up the rule book in the pharmaceutical industry, and that actually holding individuals to greater accountability rather than just shareholders or taking a bite of the profits would be a way to, I guess, incentivize people to toe the line.
I think this is a really, really important point. I think it's felt really keenly by lots of doctors that if a doctor makes a mistake, the consequences for them personally can be very serious indeed. But if they made a mistake because they've been asked to work really, really long hours, a double shift, hadn't had proper training, there is somebody in a sense who's responsible for the unsafe working conditions, and that's whoever it is who allows doctors to work under those sorts of unsafe conditions or ask them to do so. And yet you're much more likely to focus on blaming the individual at the sharp end who has done something wrong rather than the people a bit further back in the chain who have allowed this unsafe working conditions to happen.
There are parallels between somebody working in the pharmaceutical sector and somebody working in a hospital, in that we do have to look back and, with the benefit of hindsight, say, okay, what was a reasonable action given the information that was available at the time in that context. There are some cases that are way down towards one end where, given all the information at the time, this was clearly a poor decision that needs to have consequences from it. And there are other examples where actually individuals can be seen as much more a victim of the system and indeed the benefit of hindsight afterwards.
So one of the difficult things in relation to clinical negligence, which obviously doesn't happen terribly often to doctors because trials are quite unusual, but the irony here is that the more egregious whatever the doctor did, the worse in some sense, whatever the doctor did, the more likely the trust is just going to settle that case quickly and quietly with no litigation, because it's going to want to make it go away or pay off the person who was harmed. So in a sense, the worse this is for doctors, if there is a trial and they have to go to court, those would tend to be more marginal cases because it's thought worth fighting the case in court rather than really, really bad cases which will just be settled quietly. And that's sort of feels, I can imagine, from the point of view of some doctors, a bit unfair that it is maybe more marginal cases in which they would find themselves actually having to be before a court.
Although I can see the logic behind it, that seems like a strange situation to have. I think one other thing is that we should recognise that there are huge barriers to bringing legal cases forwards in the first place. Trusts recognise this, perhaps wanting to settle cases earlier. But I think also individuals recognise this, that it can be quite harrowing and difficult and potentially expensive to bring cases through. What can we do to make it easier for people in this respect?
So there's so much wrong with clinical negligence. In fact, there's almost nothing I think that's right about it. There are very, very good reasons for saying this is the clinical negligence system that we currently have is a really, really bad way of dealing with medical treatment going wrong, and that we shouldn't deal with medical treatment that goes wrong in this way. I could talk for hours about what's wrong with it, but it's really hard for doctors, but it's really hard for patients too. Bringing an action is incredibly stressful, can be incredibly expensive, and if something's gone wrong for many people, they just want to get on with their life. They don't want to relive it over a long period of time. And so the litigation itself is awful for everyone. It also costs a huge amount of money because it costs a lot in lawyers' fees. So clinical negligence means that a significant part of NHS funding goes to fund NHS lawyers, and if the NHS loses, the patient's lawyers as well. So it puts a lot of money in the pockets of lawyers rather than patient care. I think probably the best thing that we could do, in a sense, is with relation to clinical negligence, is separate out what's happened to the patient, that something has happened which means that they may have needs for additional care. They may have very serious needs for additional care. If you have a baby that was deprived of oxygen during birth, for example, its needs will be extensive. And we need to separate out the question of meeting those needs from the question of how do we drive up the safety of healthcare practice by making sure people learn from mistakes, and if a mistake has happened, that we investigate that mistake, work out what the root cause is. It might be individual incompetence, but it might also be that the system was in some ways not as safe as it could have been. And that we just, in a sense, treat those two things as different, that there's meeting the needs of the patient, and that shouldn't depend on whether you can prove fault on the part of somebody, because the needs are the same whether or not you can prove fault or not, that we meet those needs through proper care, and that we separately have a system, a patient safety system, which is to do with investigating the root cause of something going wrong, to ensure that it can't happen again. So my own view is you just get rid of it altogether and just treat patient needs in one way, and you treat driving up the safety of care in a different way. What you lose from getting rid of it is that idea of blaming individual doctors. But I don't think we lose anything valuable if we get rid of that, because I'm not sure that blaming individual doctors actually helps. There may well be patients for whom that idea of blame is really important. If somebody's done something really, if someone left something in your body that they shouldn't have left in it, or taken off the wrong bit of your body when they were meant to take away something else, so patients can feel very, very aggrieved. So you get rid of that. If you get rid of it, you get rid of that idea of individual blame. But to be honest, I don't think that is something worth retaining, actually.
And we were talking about long-term care needs going forwards here. Where does compensation for suffering that has already ended come into this?
Yes, I think that's a really, really good point. That do we think people should get money for suffering as opposed to concrete needs and care? And I think to some extent we think that they do, but we do that already in relation to in a non outside of clinical negligence, in relation to something called the Criminal Injuries Compensation Scheme, which isn't about suing individuals. It's just about if somebody assaults you and you lose all of your front teeth, for example, the Criminal Injuries Compensation Scheme will give you some money. And that's not necessarily, that will be to do with the care that you needed, but some of that could be to do with suffering. So I think we could have a component of whatever welfare payments that you're making to people as part of this non-clinical negligence scheme for injuries, where you acknowledge suffering. I think it's not undoable, is what I mean.
I see. And going back to your point earlier, I don't necessarily agree with this, but some may argue that actually a degree of individual blame actually serves as a deterrent to improve people's motivations to not be negligent. Does the current system have advantages in this respect?
So I think the short answer is that it isn't much of a deterrent, in the sense that the reason doctors provide care safely is because that's what they want to do. It's not because they're frightened of litigation. And I think that goes to the point I made earlier about if the worse, in a sense, what the doctor has done, the more likely that there won't be litigation, because the trust will just pay the patient a lot of money. So in a sense, the idea that somebody's going to think, right, I need to be a good doctor in order that the trust doesn't pay vast amounts of damages to somebody on my behalf. I mean, that doesn't really work as a deterrent. I think doctors want to be good doctors because that's what they go into medicine to do. And obviously, I think the sanction that against doctors that obviously has real teeth and works as a sanction in a way that I don't think clinical negligence does is GMC fitness to practice hearings. Doctors are worried about having their fitness to practice called into question in a way that I think negligence works as a deterrent in a way that I think doesn't really function effectively at all.
That's definitely a good point, because I wouldn't want anybody listening to think that there's no deterrence at all, because certainly there is. Now, I'd like to pivot slightly now, and if it's okay with you, talk a little bit about some of the really interesting work that you've done within the sphere of assisted reproduction. And I was wondering if we could start off just by talking about where the law currently is in this area, and perhaps what some of the more controversial aspects of it are.
Regulation of assisted conception I find absolutely fascinating. And one thing that I think is interesting about it is that we've got a statute to regulate IVF and other fertility treatments, which is actually now quite old in terms of how fast medical science in this area progresses. Because the statute is, as originally drafted, is from 1990. So we've got basically a 30-year-old statute regulating assisted conception in this country. And as a result, I think it's creaking at the edges a little bit. So I think in some ways, on the other hand, you could say it's remarkable, and I would say this is the case, that a statute that's that old actually continues to provide a framework for really, really effective regulation in this country. I mean, that's in many ways marvellous and quite surprising that it's had sufficient flexibility built into it, that it has been able to respond to new issues, whether they're social issues or scientific issues or medical developments. But yes, I definitely think it is also showing its age. And there was an announcement earlier this week where the government have decided they're going to change the law in relation to the storage. It's of eggs, sperm and embryos, but it applies mainly to eggs, because the old law was, again, a bit creaky about this, because it was designed for frozen sperm and frozen embryos, because you couldn't freeze eggs in 1990. The success rates were just so poor, it wouldn't have been worth doing. So the rules were designed around reasons why people freeze sperm and embryos, and that's generally because they're either freezing them as part of a treatment cycle, in which case you're going to use them within a few years, or because they're facing premature infertility and they need to preserve their fertility for the future. So a man who's about to have chemotherapy would freeze his sperm. So what the rules do, and this was fine when they were designed, is they say you can have an extension if you're prematurely infertile to the 10-year storage rule. But of course, a woman who freezes her eggs at 25 isn't prematurely infertile at 35, so she can't get an extension and they have to be destroyed. So the law works currently really unfairly for women freezing their eggs. So it's really a very good thing that the government have announced they're going to change this, and they can change it relatively straightforwardly by regulations in order to just have one. They have to go to Parliament, but it's not the first hearing, second hearing, third hearing. It's speedier to change this, to give that option for extension to women who've frozen their eggs. So I think that's one issue that has arisen recently. But of course, in the future, there might be some much more dramatic issues that come to the fore, for example, in relation to genome editing, if that were to become possible in embryos. Currently, that would be a criminal offence to use babies with edited genomes in treatment, so that's not possible, and you would need really serious law reform to change the law on that. So that's one thing that may come forward in many years to come.
My understanding is, and correct me if I'm wrong, that this law almost emerges by accident from a component of the law that's banned the implantation of experimental embryos.
It's a bit more precise than that. It's that you can't implant in a woman an embryo that has had its genome modified, and it is, and so when it became possible to do mitochondrial replacement, there was a big question about whether or not that would be lawful. The regulations have enabled certain sorts of mitochondrial replacements to take place, but there is actually a ban on the use of embryos with modified genomes in treatment. So you would need a change in the law there. But I think the other thing that I think is really interesting about the regulation of assisted conception is I think it would be a mistake to think that the only things that are coming up that need to be addressed are extraordinary scientific developments like genome editing, because there are other things that I think are also difficult and complicated, which are in some ways more mundane. And an obvious one is the market in fertility services. Because in 1990, I think the assumption was that assisted conception would be provided within the NHS. And in fact, the majority of fertility treatment in the UK is privately funded. So we have this rather interesting pocket, essentially, of private medicine in relation to assisted conception. And that leads to, I think, all sorts of issues for patients. One issue it leads to is the danger of overselling treatments to patients, because patients in the UK, unlike maybe in the US, they're not used to having medical treatment sold to them. It's not, we don't, if we go and see our doctor, we don't think they're trying to sell us something. So we're not, in a sense, in the same way as we are if we go and buy a new phone. We know we're being marketed to, but when we go to see a doctor, we think that they're only going to recommend something if it would be good for us. So I think we're not very well equipped to deal with the issues that arise in a marketplace of potentially misleading advertising, overselling, selling treatments with potentially dubious efficacy. And the issue that worries quite a lot of people in relation to assisted conception is what's known as add-ons. And these are extra things that clinics might say to patients might increase the chance of success. So acupuncture, for example. And some of them are quite, the evidence base for some of them is not just thin, it's pretty much non-existent. So there's some where really the view of the HFEA is that they shouldn't be provided to patients. But because they're outside of the regulatory scheme, because this just wasn't within anybody's contemplation in 1990, clinics have a very wide discretion to market these extra treatments to patients. So when you think about issues for regulation, it isn't just the extraordinary scientific development. There can be other things that we need to think about as well.
Definitely. And this brings up all sorts of questions. And I guess one of them is relating to access as well, because timely access to reproductive healthcare is so incredibly important. On one hand, you could argue that if regulation increases prices and decreases access to services, and the NHS is not offering a viable, timely alternative, then perhaps the regulation isn't serving its purpose. There is, after all, a balance between having the safest and the most effective service and actually having access to that service in the first place, a line that we have to tread.
I totally agree. I think that inadequate access to fertility treatment is a really important issue. For if you are not eligible for NHS treatment, but even if you are eligible and you have your trust funds, your CCG funds one cycle, you have your cycle, you don't get pregnant, you're then you then have to have private care. And for lots of people, this is just unaffordable, because it's £5,000 would be not uncommon for a cycle. Obviously, there sometimes people can get it cheaper than that, but that leads to a patient safety issue, which I think we should be quite worried about, which is patients going overseas for treatment in less well-regulated systems because it's cheaper. So a patient might not be able to afford to have IVF in the UK and might travel to somewhere where they might have 3 embryos put back, for example, which is a patient safety issue, which in some ways will impose a cost on the NHS, because if they return pregnant with triplets, there's huge costs to the NHS from the neonatal services and other services if the children are born with expensive needs as a result of prematurity. So in a sense, we ought to have a bit more of a joined up approach here and think if we funded safe treatment for everybody, we'd have fewer people going overseas for treatment services.
Exactly. And I know that you've written quite extensively about how this very tightly knit regulatory system can be undone by people travelling for care elsewhere. And again, it goes back to a question we've already asked, which is if this is the case, if we have these unintended consequences, then is the regulation really serving its function?
It's really difficult. I think. I think cross-border. It's not confined at all to reproductive treatment. Cross-border medical care is a really difficult issue because you can't stop people. Obviously, you can in a pandemic, but you can't generally stop people from travelling, and you don't know when somebody travels that they're going to have some really dodgy experimental stem cell treatment somewhere, or that they're going to have an organ transplant somewhere where the organs might have been harvested unethically, or that they're going to have fertility treatment that involves putting back too many embryos, or that they're going to employ a surrogate somewhere where the surrogate's welfare isn't properly looked after. So it's really hard because the internet makes it very easy for people to just find providers of alternative types of treatment and to just go and get them. And I guess what we need to do in this country is make sure that really good information is incredibly accessible to people. So if you type something into Google, rather than getting some really dodgy clinics that are going to sell you all sorts of dodgy services, what you get up immediately is evidence-based information that's reliable, that tells people what they need to look out for. So, but it's hard. I mean, I think international travel and the internet means that it's very, very difficult to stop people travelling to get things that they think that they want.
And it's very tricky when people are buying these things themselves, because I guess as a silly example, if I want to buy biros, for example, I might buy the cheapest ones I can find, and they might not work, they might not arrive on time, some of them might be missing. But then this is okay, this is a risk that I take when doing this, whereas medical care is different to that. It's one of those examples where we actually put our foot down and say, actually we are setting a threshold for safety and for price reasons. Price reasons are not good enough alone to be able to go below that bar. I guess the counter side of it is, for example, if somebody were there who really wanted triplets, for example, it naturally happens very rarely, although with assisted reproduction and implantation of embryos, it can happen much more frequently with IVF treatment. However, the UK has limits on the number of embryos that can be implanted with IVF treatment, as multiple pregnancies are seen as an inappropriate risk for somebody to be taking on from this treatment. Nevertheless, someone's motivation for this might be that they are worried that they will not be able to pay for, or local authorities will not be able to pay for, the number of IVF cycles that they might ultimately require to have a family of the size that they would like. Increased action in the UK could be a solution going forwards.
Yeah, I mean, I think you're absolutely right that if you pay, if you fund women to have IVF treatment in the UK, they're much more likely to be happy to have one embryo put back if they know that if that cycle doesn't work, they can have another cycle. If you don't fund women, they've got to find this money themselves, or let's say they only have one cycle that's going to be funded. The pressure for that to work, but also perhaps to say, well, I want a ready-made family if I can only afford one, is intense. So actually, this is one of these issues where greater public funding would actually drive up safety.
The other two issues that we very briefly mentioned at the beginning, one was surrogacy and the other was the notion of designer babies. I was wondering, how do you think about this continuum between medical benefit from genome editing and going quite a long way beyond this.
So I think obviously genome editing changes things in relation to what could potentially in the future be done to alter what your offspring would be like. So it's clear that that's why if it were to become safe enough to be used in the clinic, which by no means is the case at the moment, it would be a big deal because it significantly changes things. But the current ways in which people can use pre-implantation testing, I think, are a million miles generally away from designer babies. These techniques are usually used to avoid the birth of a child who will have a very short life or a lot of suffering, and often parents who undergo PGD have had children who've died or multiple miscarriages, multiple stillbirths. So I think one danger, and again, I think you could perhaps hold the press a little bit responsible here for sometimes slightly inaccurate reporting, is that a technique that's currently used by people who just don't want to have a child that's going to die, or want to have a child that's going to have a reasonable quality of life, are tarred with this brush of this is slippery slope to designer babies, when in fact it isn't. And that's precisely why we've got a regulator, that the answer to those sort of anxieties about using this for, I don't like to use the word wrong reason, but using this for reasons that people don't think are okay. There's a regulator that you need a license to do this. It's not something that you can just set up shop and offer to tweak people's babies' genomes. That's not possible now. Even if genome editing becomes licensable, you'll need a license to do it. The regulator can impose limits. So I think this is I think quite a good example of when there's a fear of something out there, and actually regulation can work quite effectively.
Although this is certainly something that the UK regulator and various other bodies will need to take seriously. We are only a couple of decades along from the first sequencing of the human genome, so quite where we're going to be in 20, 30, 40 years' time is a good question. It also brings up, again, the topic that we were talking about earlier, which is that if people can travel abroad for certain treatments and therapies, then this could have quite significant implications for how we think about regulation in the UK.
Yes, you're right. And I think it's not just cross-border medical care where people actually physically fly to some other jurisdiction in order to have medical treatment. But one thing that is becoming more common is direct-to-consumer genetic testing, where they're not traveling, they just fill up a little vial with saliva and post it to the United States and get an email telling them that they're less likely than most people to like the smell of coriander or some other fact about their ancestry or their risk of diabetes. So there's really interesting questions around regulation of things like direct-to-consumer genetic testing, because you can't stop somebody putting a pot of saliva in the post. I mean, how are you going to stop that? These companies are not based in the UK, and so it's actually really difficult to regulate them because people can just access them from anywhere.
I think that's certainly a really good example of that. It almost reminds me of the arguments of, okay, if you're going to do something risky, if people are going to do something risky anyway somewhere else, then you might as well legalise it and at least regulate that area to make it safer. At sometimes it might be necessary to say, okay, we are going to allow something that perhaps we're not as comfortable with, but because the unintended consequences of banning it are too dangerous to ignore.
Do you know, I think this is an incredibly important and interesting point, and a difficult one, and it arises in so many different contexts. So two that spring to mind. One is a few years ago, there was a case in which a doctor was, I think, struck off the medical register for carrying out elective limb amputations on people who wanted to have a limb amputated. because they wanted to be an amputee. There wasn't actually anything wrong with their limb. And obviously, there's very good reasons for saying doctors shouldn't be doing that. Doctors shouldn't be converting somebody who is able-bodied into somebody who isn't. So I think the criticism of the doctor is completely understandable. But of course, if you don't let doctors, if you have people who have this desire and you don't let doctors do this, there's a danger that they do it themselves, and that's worse. That's a whole lot worse, because the implications of somebody trying to get rid of their own limb are obviously incredibly gruesome. So that's a really good example of a really difficult dilemma, where you think, on the one hand, doctors maybe shouldn't be doing this, but if they don't, is actually this a harm limitation? Is it a way of limiting harm to allow them to do it? The second example where you could adopt this sort of argument is in relation to assisted dying. So currently, people in the UK who want access to assisted dying travel sometimes to Dignitas in Switzerland in order to access it. You could argue that if they're going to do that, it might be better and safer, and better from the point of view of patients, certainly, if they didn't have to travel. In terms of the benefit from regulation, you could then put regulations around that to try to make it as safe as possible, which obviously the UK has no say over what happens in Switzerland, so there's no control there. So again, I don't think there's an easy answer here, but it is an interesting and difficult question about whether or not actually, even if you're, as you say, even if you're uncomfortable with something, are there benefits from, in a sense, keeping it domestically where it can at least be regulated?
And as he said, there are so many of these examples across medicine. Drug legalisation comes to mind as another one, but also particularly given recent discussions in America relating to abortion and different laws in different states, or indeed around the world. At its core, it seems like there is really a balance between a fear of encouraging an increase in a practice that you, for various reasons, might want to discourage in a country. And does this outweigh the damage done or the risks from people doing it in a less regulated fashion? To take one example, even in areas where termination of pregnancy is opposed for moral reasons, there could still be arguments for allowing it for harm prevention, for example.
Yes, I actually think the kind of harm reduction argument for safe legal abortion is a really, really strong one, because there's quite a lot of evidence that in countries with very, very restrictive abortion regimes, it doesn't mean that women don't have abortions. It just means that they have less safe abortions. So you could say, if you were just leaving aside all of the moral questions that obviously arise here, you could say in countries where abortion is illegal, fetuses die in abortions, but women die as well, and that a harm reduction approach would then say, actually, the safest thing is to allow women access to abortion, because they're going to do this anyway, and they're going to do it unsafely if they can't do it safely.
I think overall there is a reluctance to say that something is legal because of the balance of risks and benefits if people object to that individual thing on its own. So I think it's important to be able to have these conversations in public about risks and benefits and unintended consequences of policies that can shift the balance away from what our gut feelings on them are.
Yeah, I agree. I think public communication is really central to enable people to see that sometimes there can be arguments for doing something that you might initially think feels unpalatable, but when you think about it, actually, that it's going to have better outcomes. So just another example, which is sometimes used, is in relation to criminalisation of HIV transmission. Tabloid press would have you believe that this was a great idea, but actually the reality is it's a really, really bad idea, because you can only be prosecuted for HIV transmission malicious HIV transmission or whatever you want to call it, if you know that you're HIV positive, which means you're creating a huge incentive not to find out your HIV status if you criminalise transmission. And not knowing your HIV status means that you're at massively increased risk of infecting lots of people, but with no possibility of criminal liability. So it's one of those things where even if the sort of popular press might think, no, we want vengeance and justice here, actually it's a really, really bad idea. And it's really important that you have really good medical journalists to explain the reality here rather than allowing these sort of tub-thumping tabloid headlines.
That's a fantastic example just there, I think, of which really goes to illustrate this point. And we've been jumping around through all sorts of amazing topics, but I am aware of time, so I might draw things to a close right now and just say thank you so much for speaking with me. It's been fantastic, and I hope that everyone has enjoyed the conversation.
Well, it's been a pleasure for me too. It's been really nice to talk to you. So, and your questions were fascinating and really interesting. So thank you very much.
Thanks for listening to the Pager podcast. If you've enjoyed it, do leave us a review, share it with a friend, and come back to listen to our other episodes. As ever, we'd love to hear what you think. You can reach us at Pager Podcast on Instagram and Twitter, or email us at pagerpodcast@gmail.com. Bye for now.